Good afternoon, everyone, and for those of you on the West Coast, good morning, and welcome to GovCon 101 Other Transaction Authority. I'm PCI's John Plinky, joined today by our expert instructor, Tyler Evans. Before we get started today, I want to give out some housekeeping announcements. During the program, there will be polls. The first poll is on your screen right now, asking, where do you work? In addition to that, this poll and the poll at the end asking for feedback, there will be polling questions. Not polling questions, passwords. You need to take these passwords down because you need to submit them on our website under My Certificates and Courses if you need CPE or CLP credit. In addition to that, the polls are also a part of the accreditation process, so make sure you interact with those. We invite your questions. Please put your questions in the questions panel. Tyler will handle anything topical. I'll handle anything administrative or technical. Thank you all for joining us today. Download a copy of the slides from the handouts panel. Take it away, Tyler.
Great, thanks, John. And I'm Tyler Evans, a partner at Steptoe LLP. I've been in government contracts for over a decade now, and one of my focus areas is kind of research and development, emerging technologies, things like that. And so other transaction authority agreements, OTAs, been doing that for a very long time now. PCI has been nice enough to kind of invite me back to do these types of presentations year after year. And I will tell you, of all the presentations that I do with PCI or with clients, whatever it might be, it's probably a tie between OTAs and data rights, right? Those are my two favorite, and so I'm glad everybody's here to join us today. This is absolutely one of my favorite ones. We sometimes do this presentation in a 4-hour stint. This is an hour and 15 minutes, so we'll cover some of the topics at a pretty high level, but I'm always happy to have questions. Absolutely, I can move some of the slides around, spend a little bit less time on something if you all have pressing issues that you want to discuss. We want to get to topics that are interesting to you and information that's interesting to you. So if anything's confusing, if I'm not covering something, if you want to just raise an issue in particular, more than happy to kind of go through it as we each of these. So essentially what we're doing today to look at the agenda is breaking it down into kind of 4 areas that I like to think about for kind of different buckets. So one is just table setting, give an introduction to everybody. If you're really not familiar with OTAs whatsoever, a lot of you probably have encountered them before, or at least know what they are. But what are we talking about, and why does it matter that they're different from procurement contracts? For example, we'll touch on that for a little bit of time. Then an emerging issue. It used to be kind of a throwaway topic of a slide or two, and we kind of say, yeah, you can do it here, but you can't do it there. But it's really changed a lot in the last year, I'd say. It's maybe a long time coming in the last 3 to 5 years from different decisions that have been out there. But this year we had a couple of different decisions that have changed the protest and dispute landscape. So contract disputes, essentially, with respect to OTA. So we'll spend a little bit of time and kind of focus on that specific topic as well. Agreement terms. So I negotiate a lot of these. They come in maybe once every other week and kind of provide input on kind of, well, you have to negotiate, so maybe change these terms here. You don't want to change too much. The agency is going to push back there. So a lot of those kind of practical issues that come up, we'll spend time in kind of a different module in that area. And then finally, some compliance considerations. And so there's a chart at the end, or a series of charts about, well, if you're thinking about kind of what applies to an OTA versus everything else, Byrd Amendment, lobbying, organizational conflicts of interest, things like that, we have that kind of broken down. We'll talk about kind of some of the compliance issues that come up, some of the uncertainties, some of the clear rules, all of that we'll go into as we go through the presentation. So background, kind of what is an OTA generally? What are we talking about, right? So there are many different types of government agreements, and we have a picture in about 2 slides that kind of really lays out how I like to think about the different types of government agreements that are out there. But the traditional ones that people are familiar with, if you've been doing government contracting before on the agency side, at a contractor, and a law firm, are essentially procurement contracts, right? The government buying goods and services essentially. That's the Federal Acquisition Regulation, Defense Federal Acquisition Regulation Supplement, if you're in the DoD, whatever agency supplement insert here, right? And then grants and cooperative agreements. So financial assistance agreements, subject to uniform guidance in 2 CFR Part 200. And that's what most people encounter, right? You're either in kind of the financial assistance camp or you're in the camp. OTAs are defined as something that is other than one of these 3 traditional funding agreements. So it's other than a procurement contract, grant, and cooperative agreement. Well, what does that mean, and why do they define it that way? Essentially, any statute, any regulation that talks about something that applies to procurement contracts or grants will not apply to OTAs, because by definition, an OTA is not one of those. So that's why you have something like the Federal Acquisition Regulation, which applies to procurement contracts. That does not apply to OTAs. It's other than a procurement contract. That doesn't mean, all agreements that are not procurement contracts, grants, or cooperative agreements or OTAs, right? You have cooperative research and development agreements and a whole host of other agreements that are out there. But it does mean that if you have this kind of specific statutory language about something else other than, that's where you start getting into the OTA front. And you'll see in a couple of slides that there's a whole universe of them. People talk about Department of Defense ones, or maybe BARDA, National Institutes of Health, things like that. But there are maybe, I think at this point, 30 different authorities that are out there. So we can kind of talk through and give you a sense for, yeah, it's a whole kind of universe of things in a different way for each agency that's out there. So the other thing that's kind of come up recently is I think it's important to emphasize up front, especially for the protest part of the discussion that we'll have, is that there's kind of an emerging trend. This has always been around, lurking in the background, but it's really starting to see itself in case law and the way that people talk about these things, between what I like to call kind of a agreement type or agreement vehicle. So is it a procurement contract? Is it an OTA? Versus the nature of the government action involved. Is the government buying something? Are they procuring an item? And you'll see as we kind of go along that it always used to be kind of a very simple, well, no, procurement goes to procurement contracts, financial assistance goes to grants and cooperative agreements, and OTAs don't involve procurement, and so we don't need to talk about this. But that's kind of being changed a little bit on the protest front, where people are starting to realize, well, some of these OTAs, especially when you get to production and things like that, where the government's basically taken you from prototype and gone to a full kind of, now let's produce 1,000 units and buy all of them, that looks pretty much like a procurement in terms of what you would see in a procurement contract as well. And so should we be applying some of the rules that apply to procurements, the nature of the action, not procurement contracts, the vehicle? And so it becomes this really kind of messy, nitpicky thing going along, but that's an emerging issue that I think is helpful to think about, that you can have a difference between the vehicle and the nature of the action that you're talking about overall. I think the most likely situation where you'd see coming up, if you're thinking about some of these risks, and when we get to the protest slide and all that, is in the production realm, right? So if you're doing something that's much earlier in the stage, it's a prototype, you're doing a research project, maybe even demonstration in an OTA, probably less of a risk, because somebody will say, well, it's a collaborative venture, essentially, something to that effect. But if you're now producing 1,000 units and the government's buying them, that's where you have kind of a much greater risk of, well, is it some kind of hybrid that's also subject to procurement requirements out there and all of that. So in terms of the way that I like to look at the different types of agreements graphically, I mentioned there's a whole host of government agreements, and there are different requirements that apply to all of them. So in the background, just anytime you have a government agreement, so that can be a non-disclosure agreement even, you have a host of requirements kind of in that back circle across the board. So that might be something like appropriations rules, right? So if an appropriation says you may not spend these funds on activities outside the United States, well, it doesn't matter what procurement, what agreement is involved, that requirement applies to the funds itself. And so it applies across the board. You have other provisions that are applied by law that apply to any government contract, period. And so it doesn't matter kind of what type of vehicle and all that. So you just have kind of that host of requirements beyond it. Then you get kind of specific requirements that are applicable to each type of agreement. So you have at the top there OTAs, our topic today, but then below that, the traditional funding agreements, contracts, grants, and cooperative agreements on the two sides there. And you'll see that OTAs by definition do not overlap in terms of the requirements that apply to them with contracts, grants, and cooperative agreements. But you do have some overlap on procurement contracts, grants, and cooperative agreements. So for example, the cost principles. If you're a commercial organization, you're subject to the same cost principles in the Federal Acquisition Regulation about which costs are allowable, what can you bill the government for, all that kind of stuff, regardless of whether it's a grant, cooperative agreement, or a contract. There are other examples, financial conflicts of interest, things like that, that apply across the board. But again, if all of that applies to a traditional funding agreement, it does not apply to an OTA. Below that, you'll see kind of CRADAs. So I mentioned cooperative research and development agreements, maybe a material transfer agreement, clinical trial agreement, confidentiality agreement, right? All the kind of grab bag agreements that are after that. And the big difference there, you can have kind of everything else in that category, but all of those agreements do not involve the expenditure of government funds in terms of providing funds to a contractor. So once you provide funds to a contractor, typically you have a ton of requirements that apply by regulation about what has to happen. And that's where you have procurement contracts, grants, and cooperative agreements. OTAs are kind of the oddball out, where they're not subject to a lot of requirements, but you're getting funding involved as well. So although an OTA is very flexible, like a CRADA there at the bottom, it can provide government funding, and that's why it's a very important issue for contractors and agencies overall. The Bayh-Dole Act is something that applies for inventions and intellectual property, and that applies to contracts, grants, and cooperative agreements. And so OTAs are all distinguishable from these other situations in which you get government funding, in that you don't have to follow the normal framework for intellectual property inventions in particular when you're working with OTAs. And so that's kind of another big aspect of thinking about them as kind of the oddball out with the different requirements that are out there. So now in terms of the types of authorities that we look at, I promise you it's a long list. I think I said 30. I guess my eyes are too big. It's 18 right now. Well, I guess no, there are specific subsets here as well. But these are the different agencies and their authorities out there. And so OTAs are not something that just an agency has an inherent authority to enter into. Each agency has to have OTA authority granted to it by Congress. And so you'll have each of these provisions here referencing the statute that gives the authority, in some cases, the regulation that the agency has issued to implement that authority. But that's really important because each statute sets different criteria. So they all have a common denominator. We're not procurement contracts, grants, or cooperative agreements. We're something other than, every statute and regulation that talks about those. We're not subject to those compliance requirements. But they might have other requirements that apply there as well. And so the Department of Energy, for example, might have something about cost sharing. Somebody else might have something about competition, right? And that kind of goes down the list. So I won't go through all these, but just to highlight the big ones that come up a lot. NASA, if you've ever dealt with a Space Act agreement, that's an OTA. NASA is the agency with the longest authority, longest standing authority for OTAs, going back to the 1950s. And essentially they've been flexible about this all the time. I will say NASA kind of handcuffs itself a little bit in terms of it follows a lot of rules for competition and has the whole manual of all the different things they have to comply with for OTAs, but none of that is required by statute. You then have DoD research and DoD prototype. Those are probably the most common OTAs that you'll see, potentially aside from Space Act agreements. And a lot of you are probably familiar with DoD prototype agreements. Those are very, very popular. It's kind of what most people probably are talking about if they're talking about an OTA. And what happens with the DoD prototype is if you successfully perform the prototype, that same statute allows you to go get what they call a production award. And that could be a procurement contract or an OTA, but it's essentially now we've tested it, now we've developed it, whatever it is, and now we're going into full run production and buying the thing, essentially, or procuring the services, whatever it is. And so that's kind of a big pathway for a lot of people. If you have competition on the front end for the prototype, you don't need competition for the follow-on production. It can be a sole source award. So if you're familiar with the Small Business Innovation Research Program and Phase 3 awards and things like that, it's a similar kind of concept that once you go through the first kind of piece of it, you can then get a sole source following on. BARDA, the Biomedical Advanced Research Development Authority, that's relatively niche, but if you're in the life sciences space, it's a big authority and important. A lot of that was used during the pandemic for COVID vaccines and things like that. Department of Homeland Security has its own authority. It's technically expired right now, but they're talking about extending it. We'll talk about that in a second. Department of Energy has a lot of authorities. They actually use OTAs quite a bit. I would say they're kind of third in the list of rungs out there. Transportation's another one, things like that. And then I think on USDA, there's a agriculture one, there's a Coast Guard one. These are all kind of in order now of when they were enacted. Department of Commerce, that's a CHIPS Act related. ARPA-H is another health one, DoD Health. There's an intelligence community authority. And then the most recent one was the DoD Space Launch Authority for satellites and things like that. One quick thing, there is a statement about USAID no longer being in existence. That's, I guess, depending on how you interpret it. That statute is still there and the OTA authority is still there. Whether anybody's around to use it, that's a different issue, but that statute is still around and that OTA authority still exists. But I guess a relevant point is it applies to USAID, right? Another agency probably could not come in and use that authority in that way. Okay, so now to break down a couple of different authorities and kind of some of the types of restrictions that you might see there. So these are common issues that come up across different authorities. Some authority might have a very particular provision in it about how you handle FOIA disclosures, whatever it is, but here are some ones that are typical when you unpackage each of these OTA authorities. So the first would be kind of, is there any kind of eligibility status? Do you need to be a small business, a non-traditional contractor, if you've ever heard that term before, something to that effect? Is there a cost share? A lot of these OTAs, when they came out after NASA, started with a cost share concept saying, well, we're giving you these kind of agreements that look very much like commercial agreements. You're avoiding competition in many instances. We want you to have some skin in the game. So we're going to have the recipient agree to a cost share, basically. Another would be competition. Is there any kind of competition standard? The Competition and Contracting Act that you might be familiar with for procurement contracts does not apply to OTAs because it applies to procurement contracts, and OTAs are other than that. And then is there a purpose limitation? Is there something that kind of limits how the OTA authority can be used? And all these are relevant, one, if you're the agency, making sure you're following the rules, but two, if you're not an agency, from a protest perspective or something like that, you can complain about them not following the competition standard, not following the purpose, something to that effect, if there's a very large reward, for example, to a competitor using an OTA. So looking at each of these, NASA, again, is kind of the oldest, and it's probably one of the most flexible as well. NASA has imposed its own rules, but the statute basically says, well, there's a preference for small businesses. That's it. You have to get competition to the maximum extent practicable, but there's a preference for that, right? It's not even kind of strong language in that way. Also, the authorities that they can use it for, like what types of projects can we do to actually engage in this OTA authority, are very, very broad. And so the NASA authority, can be used for a wide range of purposes without limitation. And again, that's kind of the initial authority and probably explains that result. DoD research is something that kind of came about before DoD prototype. And there it's pretty flexible. There's no competition standard whatsoever. It's one of the few OTAs without that. But the purpose limitation is really what holds you up. So there you can only use it for basic and applied research, some advanced research and development, but not really getting into the prototyping phase. If you've ever heard of DoD, Department of Defense budget activities, things like that, to the 0.4 and higher, kind of getting into advanced development and production and all that, you can't do that with a DoD research OTA. There is a cost share preference, but that's not a mandatory kind of obligation that you have to get into there. For the prototype, which is kind of, again, the most popular probably for people who have encountered OTAs, that is an interesting one in that there's kind of a combined factor. So you have to either be a non-traditional defense contractor, which means you have not had a contract subject to the cost accounting standards, full coverage under that requirement in the prior year, or a subcontract. And so if you're familiar with that requirement, detailed discussion of how you get to that result, but basically, if you had something that was 50 million or more and it was cost reimbursement or sole source fixed price, you start to ask questions, right? If you're doing mostly fixed price commercial stuff, you're not subject to the cost accounting standards, right? So that's kind of the first one. And if you're not a non-traditional defense contractor, you've received a contract subject to the cost accounting standards, you would have to give, it's mandatory, a 1/3 cost share. And so there, essentially, you'd have to make sure that when you're kind of billing the government, you're taking on 1/3 of that cost as well. There is a waiver authority available, but you have to go through that kind of waiver process. It's not just a kind of check the box, fall into this category and you're exempt from this requirement. That is a competition standard as well. And the purpose has been relatively limited over time, but they expanded it about 2 years ago. We'll talk about it on the next slide. And then there's a proposal to expand it right now as well. I won't spend a ton of time on the other ones, but essentially BARDA, pretty flexible authority. You can see there isn't a cost share, there isn't an eligibility criteria, anything like that. The big thing would be the purpose, right? It has to be for countermeasure and advanced research and development. It has to have competition to the maximum extent practicable, all that. And competition to the maximum extent practicable, if you're wondering what that is, that's not full and open competition from the Competition and Contracting Act or something like that, where you have kind of the formal solicitation and everybody's submitting against the same criteria and all that. You can do it through a broad agency announcement, for example, or a commercial solutions opening, which doesn't even set head-to-head competition. It just says the government has a general problem. We'd love to see proposals to see if you have any solutions to solve it, right? So it's a pretty soft competition standard. Department of Homeland Security is currently expired, but there's an act to potentially expand it. It probably will be expanded. And there they just mirror DoD research and prototype. It essentially is the same authority, just copied over. Department of Energy has kind of their same thing there. The note there is essentially, competition is required there. It actually has a strong competition standard for their main authority. And Department of Transportation, the only reason why I include that one here is just to show you some of these do have mandatory cost shares as well. So the Department of Transportation one, a lot of these other ones are, well, you can maybe fall in this other category or it's just a preference or whatever it is. But Department of Transportation is a mandatory cost share as they go through it. Okay. So then finally, the last of two slides on kind of table setting overall, what's happening recently in this space. I always like to kind of talk about, are they expanding authorities? Are they doing a new authority? For a number of years, it was new authority basically every year. One, I mentioned the Department of Homeland Security, DHS, it's technically expired right now. And so they're looking to expand that. That's been reintroduced a couple times. For whatever reason, it's not getting through yet. But the current plan is to have it go through 2028 in terms of expanding the authorization. The Prototype to Production and Speed Act. So these are two huge changes if they go into effect. And I will tell you that most of them are included in the Senate version of the current National Defense Authorization Act for fiscal year 2026. We'll see if they get into the final version, because I think these are pretty dramatic changes if they go forward. So the first would be currently, if you do a production OTA, so that one where you go for DoD prototype, you did a demonstration, you did some prototyping, you did some development, you showed it worked, and they said, great, now we want to buy 1,000 units. That authority is generally buying 1,000 units to go use for the military, right? What they're proposing to do, because that's a sole source authority, it's very valuable, right? There's no kind of limit in terms of how large it could be and things like that. They're proposing to allow that to be used for even further development, testing, deployment, operation, or sustainment. So if you unpack that, that's pretty much everything, right? You can basically pause it in the middle of development and say, now we want a sole source award to do even more, bigger development. Or, we just want to do operation. We want to make this run forever. We want to sustain forever, right? So it's a very, very broad authority, and that would kind of expand the production awards pretty significantly. The other one they're proposing there is just a direct to production. Don't even need to go through prototyping. You just get, if you're important enough, you get a sole source award that's a production OTA, right? Which would again be a dramatic difference in terms of you don't even have to go through kind of the basic competition of a broad agency announcement or something to that effect. The other one that I think would be huge is this Speed Act provision that again is currently in the Senate version of the NDAA, and essentially that would remove a lot of the eligibility criteria around prototype OTAs. So currently you have to be a non-traditional defense contractor or do your 1/3 cost share or get a waiver, right? This is basically saying, no, you don't need to do that, period. No cost share, no eligibility. We can just give anybody, including the Northrops and Lockheed of the world, a prototype OTA without any kind of strings attached. That would be a big change overall. And then when they change that, some authorities like Department of Homeland Security, and there's some other ones as well, are tied to the DoD authority. So that would change it for some other agencies too. I will say there's a note here. Last year they did, or I guess technically the December of the year before that, they did expand prototype OTAs for DoD to cover some of the sustainment issues and things like that, where it's kind of a, look, you can buy it and then you can also have somebody continue to service it, right? Stuff like that. But that's a kind of minor expansion compared to what they're talking about now of kind of just long-term stay in perpetual development, basically, things like that. All right. And then our kind of last for just kind of the types of authorities out there, I think and we have one question on BA, which I'll turn to in a second. The last one I'd mention about, we don't include this procurement for experimental purposes on the list of OTA authorities that were a couple slides back on all the statutes that are there. There is an authority for the Department of Defense to basically enter into what they call a contract or otherwise. And typically when you have that language, it's interpreted to be an OTA authority in other instances. And they say when you do that, you're exempt from all the procurement rules in Chapter 137 of Title 10. So that's many of the kind of procurement contract rules that are out there. And that happens if you're buying just enough to do kind of research and evaluation, basically, right? That authority looks like an OTA authority, but the Department of Defense said it's not. And so they say you can either use this authority with a procurement contract or an OTA, but you still need to go satisfy the OTA statutes. And so just if you ever see a reference procurements for experimental purposes, some agencies kind of used to say, or components of DoD, I should say, used to say, yeah, that's an OTA. We have a lot of flexibility, all that. In the last 2 years or so, they've kind of modified that a little bit. And they're basically saying, no, you need to just go on one of the other channels. It's the prototype OTA and then satisfy that. Procurement contract satisfy that. And this is just kind of another statutory layer on top. And there was a question about broad announcements, focusing on OTAs today, but can I distinguish between OTAs and broad agency announcements? So a broad agency announcement, and I reference a commercial solutions opening as well as CSO, so BAAs and CSOs, that's what they call a general solicitation in the statutes. And a general solicitation means it's not head-to-head competition. It's not everybody submitting to the same evaluation criteria and the government's opening the proposals at the same time and saying they get 5 points here, they get 4 points here, all of that. that's a traditional solicitation. BAs and CSOs are proposing to a government problem. Often the government will give a statement of objectives or something like that, and it can get kind of close with some of the government's requirements. But what's supposed to happen is each proposal goes in and gets evaluated on its own merits, and it's not a trade-off necessarily between the different offerors, because the idea is they're not proposing the same thing to the same set of requirements. I think for relevant to our discussion today, BAs and CSOs are not a type of agreement. They're just a way to procure things or to issue an agreement. And so you do see some confusion sometimes in the case law where they talk about a CSO almost like it's an agreement. That's not true. It's just a method of issuing a contract, basically. So one thing that some of you might see, it might be totally irrelevant to others, but we'll touch on it because it's pretty important to some, is a lot of times OTAs get issued through what they call consortia. So OTA consortia. And there are 2 or 3 organizations that run most of these 4 agencies. And it might be something like a consortia on armaments or autonomous vehicles or something to that effect. And it's this odd process where agencies basically contract out the process of awarding an OTA. And they've been doing it for some time, and it's pretty standard practice in some components of the government, particularly in the Department of Defense now. And what ends up happening is the agency doesn't have to kind of stay on top of contractors, a large group of staff of kind of contract managers and things like that. They basically just have a program office official that kind of knows some of the subject matter, but doesn't have to kind of do day-to-day contracting with the people. It's kind of, I think preferred by agencies because it's somewhat insulated from protests and kind of FOIA requests. So a lot of what happens in a consortia is not fully disclosed because it's happening by a contractor that's managing the entire process for the agency. And so those kinds of communications between the management contractor and others kind of get held up. And then, it's kind of almost evolved to be like a scheduled contract or a hunting license type thing where everybody joins all of these things if they're relevant, because that's the only way to get the relevant solicitations under these consortia and kind of see whether you can compete going forward. So it's an odd kind of shadow award system that's been around for some time in various areas. So how does it work? Essentially, the DoD issues and I'm using DoD as an example here, it could technically be other agencies, issues a solicitation for what they call a consortium management firm and says, we want somebody to set up a consortium, again, an armaments or space consortium or something to that effect. They come in with a group of, somebody who's supposed to be managing it, a contractor, and then their initially proposed partners or members of the consortia. They get selected, and then the consortium manager continues to bring in new, essentially, members over time who can compete for these awards. And they manage the entire process. They manage the report submissions, they manage the payments, all sorts of stuff like that. One point to consider, there was an Office of Legal Counsel memo a couple months ago saying that it was illegal to establish one of these if it was the government establishing the corporation. So this traditional process of like soliciting a contractor to be the consortium management firm, probably fine. If you're in the government, you have a great idea of why don't we just establish our own contractor or essentially organization to be the contractor and then make them nonprofit and go off and do their own thing and all that. Illegal, according to the Office of Legal Counsel. So if you see a consortium like that, there's still a couple around like that. Their current authorities may be a little bit unclear. What happens once you kind of get the consortium management board? Yep.
I'd like to come in with password number 1. The first password today is the word T. T-E-A. T. T-E-A. All right. The password is closed. Did you grab the 2 questions? I think I heard you did.
I did. Yep. Thanks, John.
Yep.
Okay, great. And so then the last point I was going to say is just what happens once the consortium's kind of up and running and all that. The management firm, the contractor, essentially issues solicitations on behalf of the agency or DoD and asks for proposals, putatively evaluates those proposals, makes the award directly, almost like a subcontract. And DoD is involved in the process, right? They kind of say, yeah, that's the contractor to go with, that's who we want the award to go to, that kind of thing. But they're not directly involved in the award or selection. And so there, it raises some interesting issues from a contracting perspective, liability, purity of contract, things like that. We'll touch on that in kind of the contract term section closer to the end. But that's kind of how it ends up operating in practice. And then we'll move on to protests here in a second, but we've got one question. Then if anybody else has any other questions, that's the first kind of section on background table setting. So please feel free to weigh in right now. So there was one question about the prohibition on contractors performing inherently governmental functions. So it's a great question. And I think the answer is because the consortium management firm. So if some of you might not be familiar, there's a prohibition in the Federal Acquisition Regulation, and then also through an OMB memo. And I would kind of question, look, maybe those don't even apply to OTAs, right? Because the FAR doesn't apply, and then the OMB memo is more towards procurement. So they might say, well, it's not technically applicable. But if somebody brings in a personal services contractor, they'll still say it applies, right? So it's a good argument it still applies. But there's a rule that says, you can't have some third party perform an inherently governmental function. So going in and pulling the trigger on a UAV that shoots somebody or awarding a contract, both are governmental functions and should not be done by a contractor is the logic. And I think that the issue here is that the government is still making the decisions by making an award to the consortium management firm and saying, yeah, okay, here's a project to go develop X. But that's submitted by basically your subcontractor, and then you're making an award to the subcontractor. So they create kind of this fiction where it's almost a contracting arrangement, and the government is just suggesting to the prime who they should be working with in very strong language. And then there's a question about consortium management firms. Are they certified? How many are there? They're not certified, and there are, last I checked, which was probably about 6 months ago, only about 3 or 4. So there are 2 or 3 that run almost all of them. It's their business. They have just convinced agencies they're the ones to run it, and they manage a large number of them. But it's not like you're talking about hundreds of different firms here. Okay, so with that, we'll dive into some of the protest pieces. But love all the questions. Thank you very much. Please keep them coming as stuff comes up. So on the protest side of things, again, this slide and discussion used to be very easy, right? So to give you the baseline that has remained the same, the Government Accountability Office will not review OTA protests, right? They will not. There's a small exception where if basically your argument is the agency did not comply with their OTA statute, which is hard to do, right? That's something like it's for the wrong purpose. BARDA issues a OTA solicitation for weapons when they can only issue OTAs for medical countermeasures, right? Okay, obvious stuff like that. Then GAO says, well, it's an invalid government agency action, and so maybe you should have issued a procurement contract, and so we'll consider a protest now. It's a weird logic, but that's basically how they do it. Otherwise, they do not consider OTA protests. They used to be a similar result for the Court of Federal Claims and the Federal Aviation Administration, which has its own protest setup. But that has really changed, I would say, again, in the last 5 years, kind of rising, but most recently in the most recent year. And that's based on the issue that I talked about of kind of a contract vehicle, is it an OTA, a procurement contract, whatever it is, versus nature of the action. Are you actually acquiring something, or are you doing some kind of research grant, right, is kind of the way I would think about it. There is still a possibility. And so what you used to have to do if you're advising clients was say, well, you could maybe object about an award of an OTA, but you'd probably have to do it under the Administrative Procedure Act. And that goes to district court instead of the Court of Federal Claims. And you're probably going to get in this whole fight about whether this involves procurement and whether this should be in the Court of Federal Claims or not. And there are a couple of cases where that happened, where it went on for 3 to 4 years, right, of just back and forth. No, you should be in this court versus that court and things like that. So it was a big mess back then. But that has really, really changed based on a couple of decisions issued by the Court of Federal Claims. So the big ones I listed on the next 2 slides to give you kind of a framework for where everything stands, how we got here overall. So initially back in 2019, there was some discussion of kind of, well, should we be hearing OTA protests in the Court of Federal Claims? And, at least the idea was not totally rejected, right, in this initial decision. And they started asking the question, well, does this involve procurement? Instead of the nature of the action, who cares if it's an OTA? If you're buying something, we should have protest jurisdiction and things like that. And they ultimately said no in that one because there was a second phase where you often have prototypes. You do your initial competition for prototypes, and then the second phase would be the follow-on, 1,000-unit production contract. And there, the second phase was actually open to competition. So the award of the prototype, they said, no, we're still in the prototype phase. This doesn't guarantee that you're getting to that procurement of production. So we're not going to get to that level. But the idea of, we could consider this issue was kind of first introduced there. ND helicopters was another one the next year in 2020, where you had back and forth between the Court of Federal Claims and District Court about who could actually hear these types of decisions. And there you actually had a District Court saying, yeah, no, if it looks like you're buying something at the end of the day, it's in the Court of Federal Claims. And so that wasn't binding on the Court of Federal Claims, right? But it's the first time a judge kind of said that. You had some discussion in kinemetrics where you have a commercial solutions opening and they're saying we might issue an OTA versus a procurement contract, things like that, just because an OTA is a possibility of an award doesn't kind of interfere with the overall protest settings. That's a rule that's out there right now as well. And then finally, you had kind of in hydraulics, essentially, there was a prototype award that said, yeah, and by the way, if you do well, we're going to issue a production award to you for 1,000 units, right? And there they said, okay, now we have a situation where it's unlike the space explorations case back in 2019, it's now 2020, and you have a contract, an agreement, an OTA that says, we're going to buy this stuff from you at the end of the day in the second phase if you do well. That's buying something, that's procurement. The Court of Federal Claims jurisdiction works on whether something's in connection with a procurement, so they have kind of a loose standard and they bring it all the way back to RFIs, request for information, and they say once the government starts thinking about buying something, it's in our jurisdiction. And so that's kind of the first case where they say, look, it's a clear case here. You're going to buy this stuff. You've set it up like you're going to buy it. You know, we'll consider it. I would say at the time, I still wasn't totally convinced because that decision involved potential to have that award made through a production contract, procurement contract, or an OTA. So there was still a possibility that a FAR-based contract was involved, and so that was part of the rationale. But then that started changing, you know, last year and then going into this year. So last year you had independent rough terrain, which basically just threw out the idea of kind of looking at OTAs period and just said, look, you need to be looking at the nature of the action. If it looks like a procurement, you know, walks like a duck, walks like a duck, that's what it is. That will be within our jurisdiction. And, you know, we can hear these kinds of protests. I will tell you, as somebody who's been presenting about this for a long time, this decision infuriates me because the plaintiff had no standing, so they should have been in court in the first place. And the contracted issue was a production contract, a procurement contract subject to the FAR, not an OTA. And yet they threw out all these statements about OTAs, right? So kind of a ridiculous statement. But then you had this year the two judges picking up independent rough terrain, and they've now established a standard saying, yeah, we're going to hear OTA protests. And they have slightly different tests. It's helpful to kind of walk through each of them, I would say. One, you know, on Raytheon and Bonilla at the beginning of the year, he kind of says it's a looser standard, but he kind of says, look, you know, if it looks like a procurement, we're going to hear it. But he admits a lot of times prototype awards, something that's more on the research and development side, it might be closer to like an investment, like a financial assistance type thing for the government. And so we're not always going to hear a protest involving an OTA. It really does have to involve procurement. There are a lot of circumstances where research and development doesn't kind of really meet kind of what we're talking about here. Then you had Judge Hertling in June issued Telesto Group, which again adopted independent rough terrain, said we're looking at the nature of the action, not the agreement itself. But he has a very odd test, I would say, that essentially there's no jurisdiction ever on a prototype or some kind of research development until there's a decision to actually go procure something. So if you get a prototype and it's left ambiguous as to whether they're going to issue a follow-on production award, jurisdiction is not out there for a bid protest until the government starts talking about getting a follow-on production award. So the long and short of it is, in the last year or two, you know, you pretty clearly have some paths to get to the Court of Federal Claims, at least for now, for these judges. Whether something falls in the spectrum of, you know, prototyping and research development versus procurement, that's going to be the big fight going on. But it's at least not a cutoff pathway like it used to be before the last 2 years. So then we'll touch on disputes. If there are any questions about protests, feel free to throw them in the chat. But disputes are much simpler, right? So a contract is a contract. And basically, the Court of Federal Claims has long recognized that you can bring contract disputes or OTAs in the Court of Federal Claims. There were a number of Space Act agreements. Remember, that was going back to the 1950s where this happened. And they basically just say, look, our bid protest jurisdiction talks about needing to be connected to a procurement. Our dispute function does not, right? Essentially, if you have a contract dispute with the government, you can go to the Court of Federal Claims. So that might even be a non-disclosure agreement breach, right? A license breach, something like that. And so if you can go to the court on those breaches, why can't you go for an OTA, right? There's nothing special about OTAs in terms of being government agreements that can be breached, right? So I think that's kind of where we are right now. I would say the recent protest decisions have raised some questions about whether you need to go under the Contract Disputes Act, which you might be familiar with. You go to a contracting officer and you submit a claim first to the contracting officer, and there's all this procedure around it and timing and all that kind of stuff. Historically, the answer was no. I think that's still probably the case, but these court decisions on protests have really thrown things in a loop. So maybe somebody would argue you have to go through the contracting officer submission process, something like that. I would say but that's still kind of an open question. Other issues that have come up over time on disputes, just to keep in mind, other transaction authority agreements are only exempt from rules that apply to procurement contracts, grants, and cooperative agreements. So False Claims Act is not specific to those agreements. False Claims Act still applies in the background, right? And so you've had decisions involving OTAs and False Claims Act claims. It's actually interesting because you're allowed to negotiate so much in an OTA. There's probably a greater False Claims Act risk in many instances. The kind of good case in this setting was a relator or a whistleblower brought a claim against a big contractor because they had negotiated a term in their OTA that said they were just going to make best efforts to make something happen. And both the government and the contractor testified, yeah, we were trying to say, like, you don't have to actually do it. Just make your best efforts, good efforts. But under commercial law, best efforts is a high standard compared to reasonable efforts, something to that effect. And so the whistleblower said, they were false claim because they really, really didn't try that hard. Ultimately dismissed, but that was probably millions of dollars later for the contractor. In terms of other disputes issues, I mentioned earlier, if you have one of these consortia awards involved, just be very careful there, because essentially the pathway to getting a contract dispute with the government is very not clear. You're a subcontractor basically, and subcontractors typically cannot bring claims against the government directly. So you might have a claim against the consortium management firm, but the consortium management firm agreements typically disclaim all liability. So it's a kind of not great situation. I would say, especially when you have sensitive data, if you're submitting that to the consortium management firm, that's a very big risk in terms of not having a recourse. You maybe have trade secret misappropriation, you maybe have copyright infringement, something like that, but you don't have a clear kind of breach of contract pathway if they're misusing the information or if the government's misusing the information as well. When you get dispute provisions in an agreement, a lot of times the government will include all sorts of, we want this to be like a collaboration or a partnership. So we want your two senior executives to talk to each other to try to resolve the dispute before going to these executives and all that kind of stuff. Be careful with those types of terms if you don't negotiate the language clearly, because that can absolutely be interpreted as an administrative exhaustion requirement. So it means you have to go through all that before you bring a lawsuit, even if somebody's infringing your intellectual property or something to that effect, right? So that type of issue is out there. And then the last two kind of niche issues, but still keep in mind, there are some bad decisions out there in the Court of Federal Claims and elsewhere that say, when something's really, really looking like a cooperative agreement where the parties are just agreeing to collaborate and the government's doing some stuff and you're doing some stuff, if there's no intent to make it look like a binding agreement with damages, they might say, look, this was just kind of an agreement to agree, a memorandum of understanding or something like that. So if you get these OTAs, they're looking much more like a strategic partnership agreement or something like that. I would absolutely put in some dispute provisions, because if you don't, there's a risk that they're going to say this was just an agreement to agree. There's no actual binding effect to any of this, that kind of thing. And then prejudgment interest, an odd issue, because these agreements probably don't fall under the Contract Disputes Act. You don't technically get interest. So even if the litigation lasts for 4 years, something like that. And so, you usually want to write that into the OTA if you can, because you can get it if you get into the OTA, but it's not available if you don't. So we had a quick question. So we regularly provide commercial items and therefore exempt from tracking costs at the job level and at the FAR. We adhere to GAAP, but are not set up to. Okay, so basically, when you talk about labor requirements, accounting requirements, costs tracking requirements and things like that, basically the question is, well, if a contracting officer demands these things under an OTA, even if we're providing commercial items, do we have any recourse? And the answer is probably not, because essentially OTAs are flexible in both directions. So most people think of them as fewer compliance obligations for a contractor, but if a contracting officer wants to impose heightened requirements, they can do that as well. And they can say, we want all the cost built up information. We want you to track your costs and all of those kinds of issues. And it's not like in a FAR-based situation, you can go to the Truth in Negotiations Act, TINA. It's now the Certified Cost for Pricing Data Statute, I think, much worse name. But there you could go back and say, well, this statute says you can't do that to a commercial item contractor and things like that. But that's all in the universe of procurement contracts and the FAR. So when you get into the OTA flexibility realm, more flexibility for the contractor also means more flexibility for the government. So if they want to be jerks about cost accounting, they can be. And we have a slide on some of the accounting issues as well that I'll touch on some of those issues. And there's a question about payment on OTAs as well. That's on one of those slides on terms, but essentially it's whatever you negotiate, right? So there isn't a universe of background rules like there is in the Federal Acquisition Regulation. So that's a blessing and a curse, because I will tell you, negotiating these things regularly, people leave out stuff all the time that nobody ever intended, but it's just always taken care of by the FAR, for example. So a good example of that is there's something called the, and this is a little bit off topic, but I think it's still helpful, the paid cost rule. So in government contracting, before they revised the regulations maybe 30 years ago, if you paid your contractor, you could then invoice the government. But if you had not yet paid your subcontractor rather, you couldn't invoice the government until you actually incurred those costs. And now the FAR says, well, if you're going to pay them anyways in 30 days, we're not going to do a hold up, just invoice us, whatever. Well, that's not the rule for OTAs, right? So if you don't write that in, you're technically charging them for a cost you haven't incurred, and somebody could object. Are they going to? Probably not. But that's a good example if there's a safety net in the FAR that's also lost when you go to OTAs. Okay. So now moving on to some of the terms. So that's the protest disputes, and now some of the kind of IP issues before more general contract terms. IP is, like many things in OTAs, completely open to negotiation, right? You can do almost anything you want. There are some rules about what you do for government inventions and things like that, if a government employee is involved, for example. But generally, if the contractor is producing an invention, new data, whatever it is, often you can negotiate almost anything you want. The catch to that is agencies are comfortable with what they're used to, right? And so the Bayh-Dole Act, which is what establishes the rules for procurement contracts, grants, and cooperative agreements of, you might have heard the term subject inventions, and you have to submit utilization reports and march-in rights and all that kind of stuff. All of that is often going to be your default in an OTA when an agency gives you a contract, or if you're drafting a contract as an OTA. It's just inventions in particular, less so than data rights, are very complicated when you think of how that works under US law for applications and things like that. And I think it's just a fact of life that a lot of people aren't comfortable coming up with their entirely bespoke regime when doing this in OTAs. So generally, you're going to get kind of the Bayh-Dole framework. And what that means in short brushstrokes is a non-exclusive license of the government for every invention that is conceived or first actually reduced to practice performance. So if you did a computer simulation, you filed a patent application, but you haven't actually made the thing yet, the government can still get that because that's a subject invention, get a non-exclusive license to it. You'll take on reporting and patent filing obligations. So you technically can't even hold the trade secret, right? If you produce something that's great, the agreement will probably say, just like the Bayh-Dole Act, okay, well, you've got to go file a patent application on it, or basically a ban on it to us. You can't maintain it as a trade secret unless you negotiate that type of provision with the government. And that's where you start getting some flexibility, right? So the non-exclusive license, no, the government's usually going to insist on that. But the reporting obligations, do you want to include provisions on trade secrets, things like that? Yeah, if there's a good reason to do that, you can negotiate that often. March-in rights, if you don't follow certain things, like you didn't report on time, you're not making an invention available to the public, stuff like that, the agency can come in and license it to somebody else, even exclusively against you. So it can say, you can no longer use it, they get to use it. That's negotiable as well, but I'd say probably not a complete deletion. It usually stays in. But if you need to remove some of the kind of available to the public on reasonable terms, which some people tie to pricing, or remove some of the manufacturing triggers and things like that, there's some flexibility as well. And then probably the most flexible of this list, typically you would have a domestic manufacturing obligation if you exclude license any of these inventions that are new to somebody else. And the idea would be, okay, well, once you've done that, we want the stuff to be made in the United States that's embodying or produced through the use of those inventions. And that's, usually pretty flexible. I would say more often than not, I probably get that removed when negotiating with agencies. There can also be situations where the agency is willing to redefine what it means to be a subject invention or one of these new inventions in which it gets rights. So for example, you filed your patent application, you did the computer simulation, you've kind of tested it, but you haven't done it actually once in practice. The agency might just be willing to say, okay, subject inventions include all these, except the one that is already covered by patent application ABC. And there's nothing that prevents them from doing that. if you give a reasonable explanation, usually you're going to be successful in that, I think. I mentioned earlier, they can't technically assign all rights to you from a government employee. So if a government employee is working with you in a lab or something like that, they can't just say you get everything, but you could get an exclusive license, right? There are ways around that, but that's kind of one of the few areas where you kind of hit a wall. And then finally, I will say that there has been a big push, particularly probably rising up from when we had kind of the first university issue of kind of foreign interests and the foreign talent programs and things like that, maybe 5 or 6 years ago in universities. You started to see a lot of OTAs include provisions, and now many include them. One set is on kind of foreign transfers, so transferring technology to ex-US organizations or individuals. And then the other is kind of access to background technology. And so a lot of OTAs you'll see now say something like, well, if the government marches in to get the rights to use the subject invention and license those to somebody else, we also want all the rights that are background that are necessary to practice that new invention. So all your pre-existing stuff as well. I think that's a huge overreach, but that's something you're starting to see more and more. That's not standard for the Bayh-Dole Act. So that's one of the areas where the government can get more aggressive in its favor instead of just flexible for the contractor. All right, and then we'll touch on data rights and confidentiality and non-use right after that. So on the data rights side of things, I just have here a layout of kind of what the FAR-based, or DFARs I should say, data rights are. You have unlimited rights as a category, government purpose rights, limited or restricted, depending on whether it's technical data or computer software. Specifically negotiate, you negotiate what you want, but some restrictions around that. Commercial rights, you want them to sign your commercial license, all those types of things. You still see a lot of that in OTAs. I would use this as kind of a baseline when thinking about data rights under OTAs, but it's not nearly as close to kind of gospel as it is for Bayh-Dole Act and inventions. So the inventions piece, the prior slide, usually you have to ask for a modification. On the data rights, a lot of times agencies are kind of working around the edges here. So they might not even reference unlimited rights, and they might say, well, we get government purpose rights and all the new stuff. They might not even reference getting rights at all in your prior data. So instead of limited rights, they get no rights, right? So there are kind of different flavors here. If you're negotiating them, just to walk through quickly of kind of the different categories, no rights is obvious. Unlimited rights, the agency can do whatever it wants, post it on the internet. You probably can't protect something as a trade secret anymore when you've given that. And that's the box there at the bottom as a reminder. Once you grant unlimited rights, it's going to be very hard to argue you still have a trade secret interest in that data. Government purpose rights, use it internally with the government or with their contractors, but not for commercial purposes. The contractor can't go run off and do their own thing with it. The government can't go post it on a website. Usually, that's all the government needs, right? And so essentially making the case for them to just get government purpose rights instead of unlimited rights, typically pretty easy in an OTA, I would say. Limited and restricted is kind of if it's technical data, use it only internally within the government. Some exceptions for support contractors. And then if it's computer software, it's only on one machine at a time, basically. You can't kind of use it as a license across all government computers. And so that's usually a pretty safe place to be. Again, in OTAs, if it's pre-existing data, either no rights or one of these limited or restricted, often where people kind of end up on that. Specifically negotiated is just, you can negotiate whatever you want in an OTA. So that category is not as directly applicable. And then the commercial rights, often the government will accept some kind of commercial license if you can make the case for commercial computer software, for example. In terms of gaps, the safety net that I said was missing from the FAR, I would be very, very, thoughtful about two critical gaps. So one, if you're on the government side of things, the FAR and DFARs often gives you some kind of rights in what they call operation, maintenance, installation, and training, OMIT, and form, fit, function data, FFF. There is also something called the detailed manufacturing and process data, DMPD, and that's what you don't get rights into. And so typically what the FAR-based contracts say is, well, you'll get OMIT rights, but not DMPD. So like operation manual, but when it starts getting into very detailed repairs, we stop the rights there. And that's always a gray line as to where you are, right? None of those exist by default in an OTA. And so I would say most OTAs I see don't talk about OMIT, don't talk about FFF, that kind of stuff. So if you're on the government side of things, you're used to having those rights, and maybe you want to consider including it in your OTA. If you're on the contractor side of things, the other gap is just based on the way the clauses work, the government often copies and pastes all the definitions from the FAR defarge provisions, but not the later provisions in the clause. So government purpose rights, for example, says the government can share data with another contractor to go work on a government contract with the government. But there's another provision in the clause that says when the government does so, it has to make the contractor sign an NDA or have a provision in their agreement that says you as the original provider are an intended third-party beneficiary. Basically, the other contractor has to do all this stuff to make it to where you as the provider can sue them if they misuse the information. But that's not worked into most OTAs. So that's another gap that's kind of on the data rights side where I typically insert that, but that's kind of something that comes up frequently. And then the last point on this slide is IR&D. I would not necessarily take this to the bank in terms of it's only one Armed Services Board of Contract Appeals decision, but it's pretty well respected. It's kind of mentioned in a couple other decisions as well. Basically, the way the standard procurement contract expense definitions work out. So you might have heard before, the government gets government purpose rights under the FAR DFARS for, just on the DFARS, I should say, for something that's mixed funding, or they get unlimited rights for government funding, or limited rights for exclusively a private expense. They make all these kind of funding determinations to see how that data were developed. Well, all of those definitions refer to contracts in a way that's been interpreted by the Armed Services Board of Contract Appeals as only applying to procurement contracts. So if you develop something under an OTA, you don't give the government rights, because let's say you only gave the government rights in deliverables, and this was developed in the progress, we never delivered the data, something like that. You don't have to then go into a procurement contract and say, well, this was developed at government expense because the government paid for it under an OTA. Just the way that everything works out, it's treated like independent research development. And so it's technically a private expense, actually, and the government gets no greater rights when you go and bring it onto a procurement-based contract after that. All right, and then the confidentiality and non-use provisions. So just a reminder, Freedom of Information Act still applies in the background here. And so when you're providing the government data, you just want to kind of consider some of these issues. So, if something's proprietary, it was pre-existing when you give it to the government under an OTA, you're probably going to be fine. There's an exemption in the Freedom of Information Act that applies to confidential commercial or financial information or trade secrets. You would have to make an argument about it. You'd have to point out the particular data that's secret or confidential, but you can make that case and probably limit disclosures in terms of somebody submitting a FOIA request, for example. There's also potentially flexibility in an OTA to contractually limit the government in how they respond to FOIA requests. So I've seen some situations the government refuses and says, no, we can't alter our statutory obligations. But basically the way FOIA works is it asks whether a document is in the government's control. And there's some case law that says, well, if the government contractually agreed, they're just going to review the information on a PowerPoint screen. It's not in their control, and so it's not subject to FOIA, right? So you can negotiate some provisions around that as well. I would say that in general, a big takeaway is that the federal government, and this is for procurement contracts and OTAs, but it comes up even more frequently in OTAs, the federal government will often say, you can provide the information to us, it's not a big deal, even if you're negotiating an OTA or something to that effect, because we're subject to a criminal statute that says we cannot disclose the information. It's a crime for us to disclose it in some way. And that's the Federal Employee Trade Secrets Act. Basically, the Supreme Court has looked at that and said, well, it's not enforceable by private parties. So as the provider of the information, you can't sue the government over it. And then essentially it's never prosecuted, right? So they say they have this big protection, but it never actually takes effect, right? So I would still be very wary of you want contractual restrictions in the OTA about what they can and cannot do with your data because of things like FOIA and all that. All right, so I'll pause there for a second if there are any other questions, but we'll get to this last slide on terms and then some of the compliance requirements as well. And then, John, did you want to wait a little bit for the second password, or is right now good?
We only have 2 passwords today, so I'm going to hold off.
All right, great. Thank you. Okay. So now some of the other terms, and this is just kind of a grab bag of issues that come up. When we do the 4-hour presentation, I go through examples for each of them and language and all that kind of stuff. But just to give you a sense for the types of things that frequently come up whenever we're negotiating these types of things. So one would be kind of defining deliverables carefully and thinking about how you're looking at data rights versus deliverables. So the first point about defining deliverables carefully, I have seen plenty of OTAs that just talk about you're going to develop this prototype thing, and it's going to be this $5 million prototype that we spent a lot of time with, and it was very expensive to build. And then it's just left open. It says, and you're going to demonstrate it. And you have all sorts of questions at the end where the government comes in and says, well, and we paid for it, now we want it, right? And the contractor says, well, no, it's a $5 million thing that we also invested in as well, so it's our computer system or whatever it is, right? So that type of thing comes up all the time. You'd be surprised in terms of the very general descriptions of statements of work, and you don't have the FAR safety nets, you don't have rules about who gets title to what, unless you work that into the agreement, even when they don't always do it in kind of a perfect way. So that's kind of the first point. The second point you see often with deliverables is the government is a huge fan now of basically taking something like a CDRL, right? So a contract data requirements list, saying here are all the deliverables that you're going to give us, and here are the data rights that are associated with them. So this report on technical specifications, government purpose rights, unlimited rights, that kind of thing. That's very risky for a contractor. So it's easy for the government because they say, well, we know what happens for the entire report. But what if in that report you need to provide a lot of your pre-existing proprietary data that would be subject to limited rights or no rights? Well, the government's going to say you have to include them in the report for us to understand it. You're going to say, well, we don't want them subject to government purpose rights. The FAR and DFARS never works on a deliverable basis like that. It always looks at the actual data categories themselves and says, yeah, a report can have this portion subject to limited rights, this portion subject to government purpose, or unlimited. And that's generally how I think it should probably be under an OTA as well. Obviously, the government can negotiate whatever they want, but basically, you're getting contractor information that's proprietary if it's not kind of done properly in terms of how that's defined for deliverables. So for performance standards, essentially there, on the performance standard side of things, there, you know, what you'd want to be careful about is most FAR-based and DFARS-based contracts have a similar risk. It's just I see it much more in an OTA. So in an OTA, often what will happen is they'll say, you will demonstrate that the object does X, right, for the prototype, whatever it is. Well, if it's a development contract and you don't know whether that's actually going to happen or not, promising guaranteed results can get you in trouble as a contractor. And that's maybe not even what the government intended, right? And so that gets back to the kind of False Claims Act issue of kind of, you know, the party said best efforts, but they really meant just try, you know, not your absolute best. And so making sure you're clear about kind of success criteria. Do they have to reach success? If they don't, what are the performance standards? Is it reasonable standards? Things like that. That's an issue that frequently comes up for OTAs. Risk of loss is another one. So you don't have the default kind of FAR-based rules, safety net on kind of when risk of loss transfers. So if you have a very expensive prototype, even if you're delivering it to the government, you probably want to be clear about who's responsible if it blows up in demonstration, right? Or it gets wrecked or whatever it is. Often these prototypes will involve some kind of risk that the prototype is lost. And if that's not written in an OTA, you don't have the safety net to protect it. So then kind of the method of payment, accounting, funding, we had some questions on accounting earlier on. So payment can be kind of unclear in a lot of OTAs. A lot of times they use milestone-based payments, but they don't kind of really clarify whether those are considered performance-based payments like they would be in the FAR, which is essentially you haven't really earned it until you kind of do the work that's there. Or is it truly a, you know, fixed milestone payment that's fully earned when paid, right? And so that kind of issue often kind of comes up whenever you're using milestone payments. In terms of accounting requirements, you know, the default is none of this stuff. FAR cost principles, cost accounting standards, all the kind of typical things you think about apply to OTAs. But the government wants some kind of assurance. Typically, you'll have some kind of a requirement about, well, we want you to use GAAP. If it's a cost reimbursement contract, we want you to track your costs. Sometimes they'll reference rules on allowability, FAR Part 31, something like that, but not always. They often say fair and reasonable, all of that. The issue that I do see come up frequently, and this gets to one of the questions earlier, is even if you have a fixed price contract, for whatever reason, most of the templates that the government uses, I think they use the cost reimbursement one and then never really appreciated why the provision was in there, say that you have to account for all the funding that the government provides to you. Well, if you interpret that literally on a fixed price contract, that makes no sense whatsoever. You have to like go back retroactively and start thinking about labor cost accounting and things like that. So, you know, most people I think kind of ignore that provision, but just be aware that when negotiating, sometimes you have a mix of these fixed price and cost reimbursement provisions in there. And then funding and limitations on liability, this is pervasive. I would say in almost every OTA that I review, it has this, and in almost every OTA, we change it if I can. there are two clauses that you might be familiar with in the FAR, the limitation on cost and limitation on funds clauses. And these are for cost reimbursement contracts or contracts that have a cost reimbursement component, basically. And they say, look, we've obligated $50 million to this agreement. If you go over, or you're getting close to going over that, you need to let us know. And ultimately, if you do, we're not responsible for anything over the ceiling, right? And that's kind of in there for compliance with the Anti-Deficiency Act. You can't obligate government funds without authority to do so. And so if they've parked $50 million on the contract on the agency side of things, and you're suddenly saying, well, no, you owe me $10 million more, they don't have the funds for it. They've never signed up for it. You have to go through a whole process for that, right? And so that's what those clauses are intended to do. Unfortunately, on OTAs, that language and logic has been ported over not just for payment for performance, so I did the work, now reimburse me for my expenses, but for all liability. So they say, oh, no matter what, we don't have to pay you over the amount in the contract. And I would say just consider things like confidentiality, stuff like that. If they breach data rights or confidentiality provisions, that means your damages for those provisions are capped at the agreement amount. And that might be hugely disadvantageous to the contractor in terms of the harm to their company versus the liability of the government. On the government side of things, I would also say, it's damages for something like breach of contract come from the judgment fund, which is basically an open appropriation to pay. It doesn't come directly from the agency's budget. And the judgment fund has to be reimbursed if it's a procurement contract. But if it's a OTA, it does not have to be reimbursed. So it's essentially free damages from the agency. I know it's bad to think about it that way, but in terms of the impact on the contractor versus impact on the agency, I think it's very disproportionately bad on the contractor when you have those types of limitations on damages. So I usually say that's capped for performance reimbursement, basically, not for all potential damages, including breach. So then, it's usually helpful, not required, but it includes some provisions on background data, inventions, that kind of thing, making sure you put down a marker in the sand of what is the contractor's pre-existing stuff versus the new stuff. Again, that's not default, so having your own kind of provisions on that is helpful because in the FAR, DFARS, you would have that safety net. Things on termination of disputes. So on termination, often the government's unilateral right to terminate for convenience is not clear. So if you're on the agency side of things, you want to consider, look, do we have a strong enough termination right in here? And if we do we have to pay the contractor? What happens in that result? Typically, you don't have that kind of level of detail. And then on the dispute side of things, I mentioned the exhaustion procedures, prejudgment interest, whether you can go to court directly for something that's imminent, right? And you can't typically get injunctive relief from the government, but at least getting some kind of declaratory relief or something like that. And then on tangible property, there are almost, I wouldn't say never, but half the time there are no provisions on tangible property. And if they are there, they're not totally clear. And you just want to be clear about, if you're buying things under the agreement, are those the contractors or are those the governments, right? And in a FAR and DFARS based agreement, if it's cost reimbursement, typically the government would take title and only take title, and in a fixed price contract, they'd only take title of the final deliverables. Well, often OTAs have kind of vague language that suggests either way. Maybe the government gets title to items even though it's a fixed price contract, which is kind of, the government is basically double dipping there, right? They're getting the item, but then having kind of the ability to just give a fixed price to the contractor. So there are a lot of issues that come up on the tangible property as well. And then finally, on Department of Defense, just important thing to realize that there are some export controls that apply for essentially what they call developmental items. So these can be developmental countermeasures, aircraft, vessels, things like that. And so you can imagine this comes up for OTAs much more frequently than it does for procurement contracts because OTAs typically involve some kind of development, some kind of prototyping, things like that. And those export controls trigger unless the agreement with the Department of Defense says that the items being developed are for both military and civil applications. If it doesn't include that language, you're suddenly subject to the U.S. munitions list and ITAR. And so a lot of times that's not in the government or contractors' interests, and it's important to include that type of language if you think you're falling into one of those categories. All right, so our final section is on some compliance obligations for our last 5 minutes here or so. We won't walk through absolutely every single thing, but just to give you a sense, I'll pause here as well, see if there are any questions on what we've covered so far. Okay, so in terms of the kind of requirements that are out there and how they apply to OTAs, This list I've developed over time from lots of research and kind of statements in congressional records, GAO, things like that, to kind of say, look, requirements that apply to procurement contracts, they don't apply to OTAs. Maybe some that apply to procurement, the nature of the action do, and that's where we get some gray area. But going through that process is kind of how you get to this list. So full and open competition, Competition and Contracting Act, all that kind of stuff for procurement contracts, not applicable, right? You don't have to go through all of that. You have a lesser standard in most scenarios. All the technical data rights, no. You can negotiate whatever you want on data rights. That kind of stuff does not apply. Types of contracts and payment. So you have to treat milestone payments like performance-based payments. No, you don't have to do anything like that. Kinds of contracts, it doesn't have to be a very specific cost reimbursement, time and materials, whatever it is. You can have all sorts of hybrids, things like that. Certified cost or pricing data, we talked about TINA earlier. That's not applicable whatsoever. Agency audit rights as opposed to the GAO or Comptroller General audit rights, though they're not directly applicable, although they'll often negotiate them. Cost accounting standards, we mentioned that. Byrd Amendment is a lobbying statute. That's not applicable if you've ever seen the Form LLL, kind of disclosure of lobbying activities. And then some of the basic whistleblower protections as well. Likely inapplicable, here there's a good reason, but probably something that's making us pause a little bit, right? So a lot of the kind of wage-based statutes, so Service Contract Act, Walsh-Healy Act, things like that. Department of Labor has suggested the Service Contract Act could apply not to OTAs in general, but any type of government agreement. So there's a little bit of ambiguity there, but it depends. Anti-Kickback Act, that's one of the ones that talks about procurement in general instead of the vehicle itself. So maybe it does apply, maybe it doesn't. Buy American Act clearly does not in most statements, but you have had some lists where somebody has listed it as well, maybe. So there I'm a little bit less confident on it. E-Verify, Privacy Act, things like that. All the small business contracting rules, subcontracting rules, nope. Drug-Free Workplace Act, no, but there are some agencies that apply it by policy to OTAs. You just have to look at their policy document. Human trafficking, confidentiality agreement restrictions, so whether you tell your employees they can't report waste, fraud, or abuse to the government, that kind of stuff, probably not applicable. Conflicts of interest, same kind of thing. And Procurement Integrity Act, whether you're getting access to source selection information or other bidder proposal information, in most instances, no. But the prototype DoD authority by statute has the Procurement Integrity Act apply to it. So that's the one exception there. And then let's see really quickly just some of the questions we have before the last piece here. So just the types of audits that agencies normally perform on OTAs. So often an agency is not, they might insist on having an audit right, but they generally don't go through a normal audit process for that. So the types of reviews you're looking at are much more like, do you have proof of what you're billing on a cost reimbursement contract? Are you using a negotiated indirect rate that's been approved by DCAA, something like that? I have never seen an OTA that says you need an accounting system approved by DCAA, for example. That should be something they're probably doing, but they generally do not get to that level of detail on the audit rights. The question about White House executive orders on taxes and tariffs, I'd say that's, probably a little bit out of scope. I would say that for DoD in general, there is an old, it's in the FAR, but they could apply to OTAs as well, an old authority for essentially treating duties for many, many DoD contracts as exempt. And the last set of rules that I looked at, now it's been a couple months, but you could probably apply those on the Department of Defense side to say you're exempt from new taxes and tariffs that are coming out. And then the milestone payments, so essentially that issue I was talking about, if you have milestone payments where they're not clear about whether it's a performance-based payment, which is a financing payment, you have to earn it, it's not considered earned when paid, or milestone that's just here's the lump sum of money, you already earned it, and the OTA is not clear about that. What's the recommended course of action? Obviously not giving specific advice, but generally I would say if the agency is kind of treating it not like an advance payment in some way, probably okay to not treat it like that yourself as well. You could ask, but obviously they would probably say, oh yeah, we'll treat it like it's an advance, right? So I think that's potentially an issue. And then the title, if it's unclear about who gets title to property purchased under an OTA, I would probably follow the FAR-based rules. So if it's a fixed price OTA, you would just argue, look, why would we also give you title? That kind of doesn't make sense based on our pricing. We didn't price for that. We priced for keeping the property itself. But those are good questions on things that can come up. And then I think I think that does it for the questions. The last one, here's some ones just to show you that are potentially applicable, right? You have some definite gray area here. So the Anti-Assignment Act, you might be familiar with novations and things like that, whether you can assign government contracts, probably applicable to OTAs, right? Not totally clear, but probably applicable. The Cargo Preference Act was amended a number of years ago, maybe 5 or 6 at this point, probably applicable as well. It has very, very broad language about the types of contracts to which it applies. This is whether you have to have a U.S. flag vessel, transporting goods, things like that. Fly American Act, whether you have to use a American plane, basically for travel, and then some of the administrative stuff. So SAM requirements on unique NI identifiers, subcontract reporting requirements for ESRS, stuff like that. Probably still need to do it, although I think most OTA holders do not do that. And then some of the kind of broad requirements about uses of items in government contracts. So some of the, doing things with debarred entities, some of the Section 508 accessibility requirements for information technology, all that kind of stuff is probably applicable as well. So that's the end of our presentation. And again, if there are any more questions, happy to talk now or offline, but I think we're about a minute over, so really appreciate everybody's time, and I'll turn it over to John for the last password.
All right, the last password today is the word leaves, L-E-A-V-E-S, leaves. Write the word leaves down. You'll need it after the session if you need CPE or CLP credit. All right, everyone, next up, the feedback poll. Tell us how we did today. We hope we did great, but if we didn't, we would like to know. All right, thank you all for joining us, and we hope to see you again soon. Bye-bye.
All right, thank you all. Have a good one.